Um, Hello, everybody. Welcome to this HKU Center for Comparative and Public Law book talk. My name is Rehan Abiratna. I'm an associate professor of law at the Chinese University of Hong Kong, and I'll be chairing this event. We have a terrific book and panel today. Let me hold up the book. The book is Responsive, let me hold it up a bit better. There we are. Responsive Judicial Review, Democracy and Dysfunction in the Modern Age by Rosalind Dixon, published by Oxford University Press earlier this year. Let me introduce the author and our two discussants quickly. So first, the author, Rosalind Dixon, is the Scientia Professor of Law at UNSW Law and Justice. She is a Manos Research Fellow and Director of the Gilbert Tobin Center of Public Law, Deputy Director of the Herbert Smith Freehills Initiative on Law and Economics, Co-Director of the UNSW New Economic Equality Initiative, and academic co-lead of the Grand Challenge on Inequality at UNSW. I should also mention that Roz published another great book recently, I think last year, with Richard Holden, called From Free to Fair Markets, Liberalism After COVID-19, which too was published by Oxford University Press. Let me also introduce our two discussants. First, Po-Jen Yap, who is Professor of Law at the University of Hong Kong. He's the author and editor of many publications. His latest monograph is Constitutional Convergence in East Asia, published by Cambridge University Press in 2022. And most recently, the Rutledge Handbook of Asian Parliaments, which he and I co-edited, and to which our other discussant contributed an excellent chapter. He's also the director of the Center for Comparative and Public Law, which is hosting this event. And last but not least, we have Dinesha Samararatne, who is Professor of Law at the University of Colombo. She's published widely on important topics, both Sri Lankan and comparative constitutional law, including on public participation in constitution making and transformative constitutionalism. She's also a member of the Sri Lankan Constitutional Council. So welcome and many thanks to all of you. So the format for today is as follows. Roz will first introduce the book, followed by comments from our discussants, and then a response from the author, if she so desires. We will then have a Q&A section, or session, I should say. So members of the audience, I believe there's a Q&A button at the bottom of your screens. So you can click on that and type in your questions. And then at the end, I'll select some of those questions for Roz and the panel. So with that said, let's begin. Roz, could I invite you to introduce the book, please?
Thank you so much, Rehan. And I want to start by thanking the Centre for Comparative and Public Law at HKU for putting on this event. The CCPL is a partner of the Gilbert and Tobin Centre of Public Law, and we're absolutely delighted to be working with Po-Jen and colleagues at HKU in this context. I really have loved following some of the other book seminars in the series that the CCPL has put on, and it's a real privilege to be joining virtually as part of that series. I'm joining here in Australia from Bidjigal land, and I pay respect to the elders past, present and emerging, who are the traditional custodians of this land. I also want to say what a delight it is to be on a panel with Professor Yap, with Professor Samararatne and Professor Abiratne, all of whom, as you've heard, have written about legislatures and judicial review in South Asia and common law Asia. And I've learned so much from all of their work. Some of the work in the book draws on early ideas about dialogue, about which I have been in conversation with Po-Jen about for decades, unfortunately, for both of our ages, but really fruitful and enriching exchange from our time together working with Mark Tushnet at Harvard onwards. And I feel that I've learned a lot, Po-Jen, from your work, and your understandings of dialogue and remedies have informed the work in the book. Similarly, Dinesha's approach to thinking about how one does constitutional theory in a globalized world where the concerns and voices of the global south have to be taken seriously and engaged with as part of any project in constitutional theorizing have really shaped both the ambition and also the limits of what I try and do in the book. And Dinesha, you've generously written an article engaging with it specifically in a Sri Lankan context. And I think that the way in which Dinesh offers an account, which no doubt she'll share with you in more detail, of a Sri Lankan RJR-inspired public trust doctrine, are really fruitful and generative. But I particularly want to pay tribute to your role in helping me think through how one does constitutional theorising in a manner sensitive to concerns about Global South, voices, scholars' perspectives and experiences. And Rehan, you have been a wonderful interlocutor as well, and some of the work you've done I've relied directly on, but also you've inspired conversation around the role of individual judges, which has been really important in shaping some of the ways in which I talk about judicial capacity in the book. I also see attending friends new and old. I've particularly benefited from Pui Yin Lo's work in understanding Hong Kong, and Cora Chan, of course, has been a great interlocutor and supporter, and her work you'll see reflected in my chapter on calibration and how one should think about deference. Cora's work on this is, second to none and so nuanced, and I really recommend it to you when it is too in monograph form, and we do something just like this in the coming months and years to celebrate that work. There are others there I could talk and thank, including I know a new colleague joining you in HKU, Stefano, who's going to do great work picking up some of the themes of the book on LGBTQI+ rights. But now let me introduce the argument of the book. Phoenix, if I may, the slides would be of assistance in this context. The book began a long time ago, coming out of my doctoral work, really interested in this idea of dialogue. But recent events have made me convinced that it's important to try and twin a concern with dialogue in well-functioning democracies with a concern for how courts should engage in judicial review in democracies under stress or at risk, experiencing what some of us have called democratic backsliding, abusive constitutionalism, democratic erosion, and the like. And against that backdrop, it tries to bring together an account of judicial review that can encompass those two democratic contexts. So the starting point of the book is that when it comes to constitutional adjudication, a court is always focused on a text. They start in a given context with a document that is a written document, and they have to interpret that document. And sometimes there will be a sufficiently determinate answer that the text alone provides the solution for a court. More often than not, however, it won't. And courts will look at history and structure and prior case law, in which case they might find answers to concrete problems. But even still, taking this into account, they may find that there is indeterminacy or that legal results are open-ended. And in that context, in other work, I have argued that courts should look to constitutional values in ways that inform their approach to interpretation. In an Australian context, I've called that a functionalist approach, and it will be familiar to many of you as a purposive or, in some ways, values-inflected approach to constitutional construction. But in this context, there are still choices to be made by judges about how to balance competing values, how to give some values priority compared to others. And in this context, one of the arguments of the book is that democracy should be a key determinant in thinking how to balance competing modalities and values. But democracy itself is a contested value. It can be understood in thinner or thicker ways, and in ways that have been very much the subject of debate. And one of the things I try and do in the book is take a view of democracy that is explicitly thin and thick at various points and combines them in a specific kind of way, informed by theory, but also comparative practice. This is in very obvious ways inspired by the kind of account of representation reinforcement offered by John Hart Ely in Democracy and Distrust, but it tries to update it 40 years on to give an account of democracy in courts that is both more comparative in origin and derivation and more attentive to the ways in which democracy is threatened today, as well as one that answers the most direct challenges to Ely in the form of criticisms by scholars such as Larry Tribe and others of the overly sharp distinction he sought to draw between process and substance in constructing a representation reinforcing account of judicial review. Next slide. Thanks, Phoenix. So before one starts to think about what courts can do, as I do on this slide, it's useful to just state briefly the conception of democracy that I'm operating with. The conception combines thin and thick understandings in the following way. It says that the thinnest understandings of democracy, which are focused on elections, are an important starting point for thinking about constitutional judicial review, but they need to be built out to encompass at least three dimensions. And this is what David Landau in our joint authored work have called the democratic minimum core. A minimum core of democracy that can be derived from an overlapping consensus among different constitutional theories and political theories, and by looking at extant practices in constitutional democracies worldwide. And we say that that democratic minimum core consists in 1, a commitment to regular, free and fair multi-party elections; 2, minimum political rights and freedoms; and 3, institutional checks and balances capable of protecting the first and the second ideals. That's the minimum core, we say, that is part of a thin conception of democracy that almost no reasonable theorist or citizen could disagree with. But then there are thicker understandings of rights and deliberation that fill out what democracy, as certainly constitutional democracy, is. And that is at the heart of a theory of responsive judicial review, but I suggest has to be understood through a lens that acknowledges reasonable disagreement about what these commitments entail. So this is the political constitutional turn, which plays a central role in many theories of dialogue and certainly a theory of responsive judicial review. Putting those two theories together, I identify 3 potential sources of democratic dysfunction. The first is the accumulation of electoral and institutional monopoly power in a way that undermines the democratic minimum core. 2, forms of blockage in the democratic process that undermine thicker conceptions of rights and deliberation, even as understood by democratic majorities. And here we see the role of democratic blind spots and burdens of inertia as a central part of my account of how democratic processes can fail to live up even to quite undemanding understanding of what rights protection looks like, namely claims that are made by minorities, but at least supported weakly by majorities, that the legislative process fails to deliver on. Here, I suggest courts can and should play a role in protecting and promoting democracy by seeking to counter all of these 3 sources of democratic dysfunction. In the book, I go through a range of examples. I talk about social rights, about abortion rights, about LGBTQI+ rights. I talk about varying implications in Israel and Australia, as well as the unconstitutional amendment doctrine that various scholars on this call and attendees are expert on. In practice, these different sources of dysfunction overlap, and they can wax and wane, and people may disagree about their presence. For instance, I do quite careful work trying to characterise public opinion and considered majority opinion on issues of transgender and LGBTQI+ rights in Hong Kong, in India. But those are matters of open and ongoing reasonable disagreement. And I rely heavily on the work of scholars at HKU and elsewhere, but I admit that there is definitely scope for contestation. Another key part of responsive judicial review, however, is an emphasis on the limits of appropriate judicial power and the risks to democracy of an overly strong form of judicial review. Here, I point to 3 key risks, the risks of reverse burdens of inertia, democratic backlash, and democratic debilitation. Reverse inertia arise where there is reasonable disagreement and limited scope for legislatures to engage in dialogue with courts. Backlash is a more instrumental concern about attacks on courts as institutions capable of protecting the Constitution and upholding the rule of law. And democratic debilitation is a danger identified by Mark Tushnet and fleshed out by others, including my co-author David Landau, and which points to the fact that if courts are too good at their job and too consistent in countering dysfunction, they may give little incentive to legislative and executive officials to improve their own performance in fulfilling their constitutional obligations. Next slide, please, Phoenix. So the implications of this account an account that takes seriously the benefits of judicial review in countering democratic dysfunction, but also the dangers in terms of creating new sources of democratic dysfunction, are several. The first is a commitment to a variable and context-sensitive approach to the scope and intensity of judicial review, which cashes out in a variable approach to the legitimacy of constitutional implications. When one uses the word legitimacy, obviously one is conjuring up a vast and important literature. And one of the things I do is engage with the work of Richard Fallon at Harvard Law School in particular here, and interpret his understandings as pressing on sociological, legal, and moral political notions of legitimacy, and suggest that when we think about legitimacy in this context, it is useful to think of legitimacy as an amalgam of legal and political and a sliding scale. Where a court is seeking to protect the democratic minimum core, I argue that the political legitimacy of that approach provides sufficient basis for judicial decision, even where legal legitimacy is weak. But conversely, where a court is responding to blind spots or burdens of inertia, it would need a much stronger legal basis or showing of an irreversible and serious risk to human dignity in order to justify an implication of that kind. I likewise argue that responsive judicial review suggests a carefully calibrated approach to proportionality style judgments, which could be seen as a form of hybrid between the kind of tiered scrutiny endorsed by the United States Supreme Court and a German European style model of proportionality, which is more open textured. Many countries, as I hope Pojen and others may explore more fully in common law and East Asia, have gone down something like this path, but I could construct a theoretical account of what this could and should look like from a responsive perspective. Again, here is a place where, going back to my opening remarks, I would highly commend the work of Cora Chan as a complementary account of this kind of calibration. And thirdly, drawing on Pojen's work in this area, as well as other work by Rayhan and others on remedies, I suggest that responsive judicial review translates into a mix of strong and weak review. Where the democratic minimum core is at stake, a commitment to strong review softened by appropriate weakening for prudential reasons. But where the democratic blind spots or burdens of inertia are at stake, a more principled softening or weakening of judicial review in order to accommodate concerns about debilitation and potential reverse inertia. You will see the list there of the functions of weakening review, which is about safety valves, disagreement, and practical periods of adjustment, but the biggest emphasis being on safety valve and disagreement. One of the things about Asia is that it is home to a rich variety of different forms of weak remedy, which, if we look at Hong Kong, Korea, and Taiwan, have much to teach the rest of the world about how responsive judicial review could be operationalised in practice. Next slide, please, Phoenix. One of the things, however, that I have emphasised and that I emphasise in new work on responsive remedies with Pojen is that judicial review in a responsive approach is weak strong, not weak across the board. It is not British-style, United Kingdom Human Rights Act-style relief with no prospect of coercive strong form relief. When you have a would-be authoritarian actor trying to amend the Constitution, circumvent checks and balances, destroy the independence of the fourth branch, strong remedies may be required and should be used. And it is part of the theory that there is a commitment to using the full force of judicial power where necessary to protect and promote democracy. But equally, a concern to do so in a way that is sensitive to concerns about dialogue, and that distinguishes between cases of dialogue and backsliding in a more crisp and clear way. Operationalising a commitment to weak, strong review can be complex in practice, And here I draw attention to the work that Po-Jen has done about using weak review with bite, David's work on aggressive weak form review, and my own ideas in the book about weak strong review and penalty defaults as a useful way of thinking about the balance that could be struck in this context. Next slide, please, Francis. Another part of the book, which, as I said earlier, was informed by work that Po-Jen, that Rehan and Ido Parat led on towering judges, and my own work on strong courts, was to think about what kinds of judges might be capable of doing this kind of review using what kind of judicial statecraft techniques. And that word statecraft is one I owe in this context to Yvonne too. One way in which this occurs is by courts using the weak, strong remedial structure created by responsive review to engage civil society in a constructive, collaborative approach to constitutional implementation. But another dimension involves self-conscious decisions by courts about how to frame their decisions in ways that are designed to maximise support for the decisions among civil society, government, and disappointed litigants. And this, I argue, involves courts thinking about who writes for the court in cases where there is a disappointed party and trying to find ways to make sure the party is assured that the court has given full and fair consideration to their claim, by indeed thinking about whether the author of the court's opinion should be the judge with the lived experience or professional background closest to those disappointed by the result. Thinking about a tone of respect that is designed to elicit comity and compliance from the elected branches of government. And a narrative, and Dinesha and Will Partlet have done really important work on constitutional narratives and nationalism, thinking about a narrative that can explain a decision to a diverse audience in ways that draw on both universal principles and local histories, commitments, and values. In that way, I suggest that courts can not only be mindful of the limits on their own legitimacy, but in some ways seek to push the outer parameters of their sociological legitimacy by increasing support for and compliance with their decisions. Last slide, please, Phoenix. So in conclusion, I try and construct an account that I recognise has important variation across countries and that must be filled out by reference to specific histories, contexts, and experiences. And yet it does draw on countries across the global north and south in all continents to try and offer a generalised account of what democracy, representation, reinforcing judicial review can and should look like, with appropriate adaptation to the context in which it is deployed. It is an account that assumes relatively strong preconditions: an independent judiciary with a supportive legal political culture and adequate judicial remedies. And one might also argue some degree of role conception that supports this kind of review. But as Po-Jen and others have pushed me to think about earlier elsewhere, courts could do part of the idea of responsive judicial review at times without doing all of it. So in a dominant party democracy, they may be able to do more work countering blind spots and burdens of inertia than they could in protecting the democratic minimum core. But their response would still be partially responsive and usefully informed by a dialogue with these theoretical ideas. There are important questions about the kind of judges that can do this kind of review. They have to be judges with a sensitivity to law and politics and with a certain command of both legal and political context and considerations. But it is the case, in my view, that even one or two judges on a court who are respected by colleagues would be capable of leading this kind of approach. Judges can do this intuitively and implicitly without knowing that they are doing it. And with the benefit of structured debate of the kind that we are engaging in today, we offer a template for judges minded to adopt this kind of approach that makes it simpler, clearer, and easier to adopt, albeit with appropriate attention to contextual difference. I'm very much looking forward to hearing your thoughts, but I do want to acknowledge that Hong Kong Law Journal has produced a very soon to be released special issue on the book, which draws on the expertise of some of the absolute leading thinkers in Asia around how that adaptation could occur. And I'm incredibly grateful to colleagues, including Dinesh, for that work, and look forward to engaging it more publicly in the months to come. Thank you so much, Rehan.
Terrific. Thank you very much, Roz. Covered a lot of ground there in a very short time. Let's turn over to the discussants. Pojen first, please.
Thank you, Rehan. So it's a huge pleasure and privilege to be commenting on Professor Dixon's groundbreaking book. I will try to put it here. Right. So I believe that I have not much to actually criticize the book about, because Roz and I have been dialoguing on this topic for years, if not decades. And so to a large extent, my commentary would be, in a way, dovetailing with all the arguments that she has been talking about. But what I'll try to do is try to hone in on its relevance to our region and to the city that we live in. So in particular, I'll look at how judges can exercise responsive judicial review in Hong Kong. Right? So Ross' main claim, or one of her central claims, is that judges has to be responsive when they exercise the power of rights review. The idea is judges should not settle all constitutional issues, but should give room for legislature to input their ideas and to allow for responses and for the deliberation after the ruling is passed down. And it's my view that judges can do so in Hong Kong in two ways. The first is judges can do so by engaging in rights-friendly statutory interpretation. Instead of merely striking down legislation as unconstitutional, sometimes as part of the toolkit of judicial review, judges can simply read the legislation in a creative, rights-friendly way. And I'll give some examples from Hong Kong, right? This Hong Kong CFA, Court of Final Appeal, has held that when offense-creating criminal provisions are silent or ambiguous as to mens rea, the more serious the offense, the more likely they will infer and presume that mens rea has not been displaced. So to this end, the CFA in the case of Choi Wan Loon held that a criminal provision that prima facie seems to have removed all mens rea did not do so in substance. On the facts, the question was about the criminalization of indecent assault on a minor. While prima facie, the law seems to make mens rea irrelevant, the court held that on its construction, what the law did was to merely absolve the prosecution from proving mens rea as to the girl's age. But the accused would still have a defense if he can prove on a balance of probability that he honestly and reasonably believed that a girl was 16 or above. One should note what the CFA was doing here. In essence, the court was construing ambiguous criminal provision in ways that advance substantive values of due process. But at the same time, these new principles are mere common law, clear statement rules that allow for the legislature to override the court's presumption by ordinary legislation if the legislature so chooses. In other words, all the LegCo has to do is to simply statutorily remove the due diligence defense that the court has imposed. But until the legislature does so, the CFA has imposed a new default rule that enhances criminal process for the accused charged with serious crimes. Vis-a-vis Hong Kong's famous national security law, it seems that the CFA has also implicitly endorsed this method. right? In that case of Lai Chi-ying, the court held that the NSL itself expressly stipulated that rights, freedoms, and values are to be protected and adhered to in applying the national security law. And they provide the context in which the national security law must be construed and applied. And according to the court, as far as possible, right, the right to bail, or the bail provision of the NSL, is to be given a meaning and effect compatible with rights, freedoms, and values. So whenever courts engaged in creative statutory construction, what they do is, as Ross has pointed out in her book, is to reverse the burdens of inertia, right? They place a new default by reading a certain legislation in a more rights-friendly way. If the legislature disagrees with this new default, the legislature can use legislation to overturn and override by using ordinary legislative political process. This is different from merely striking down the law such that the law cannot be addressed, or at least any remedies cannot be addressed using ordinary legislation. The second way courts in Hong Kong have engaged in response to judicial review is in its use of remedies. And I think Ross and I, we are writing a book on how delayed remedies provide a mechanism for courts in Hong Kong and around Asia to showcase its responsiveness or its openness to legislative responsiveness, right? And we note that courts in East Asia have increasingly used suspended declarations of invalidity as a means of promoting dialogue with the legislature, right? In fact, based on my past research, right, suspended orders are most ubiquitous in Hong Kong, Taiwan, and South Korea. I've explained in a former book why this is so, but in a nutshell, for judges to issue suspension orders regularly, courts must be able to trust that the legislatures will, more often than not, engage with them and enact corrective legislation during the grace period. South Korea, Taiwan, Hong Kong are all first world economies with legislatures that dialogue with courts. Even as Hong Kong is more authoritarian than before, the city's continued importance as an international financial center, fourth in the world, it used to be third, undergirded by a respected independent judiciary, is indispensable to Beijing for linking mainland China to the world economy, such that China, through its state-owned enterprises, can generate capital in Hong Kong to fund its domestic and foreign policy ambitions. Therefore, the local and the central governments have the economic incentives to respect Hong Kong's judicial rulings generally to sustain global investors' confidence in the city's rule of law, which is pivotal for Hong Kong to maintain its international financial center. Right? Hong Kong wants to be third again and displace Singapore that has taken over it, and definitely Hong Kong doesn't want to be fifth and allow for San Francisco to take the lead. For Taiwan, we see dialogue in action, for example, when the Taiwanese Constitutional Court ruled in 2020 that the statutory provision which imposed a minimum of 5 years jail on all offenders convicted of cultivating marijuana was disproportionate. But at the same time, the court gave the legislature 1 year to decide what should be the appropriate punishment. In the end, the Legislative Council, after deliberation, revised their law, and now the courts can sentence offenders who cultivate marijuana for personal use to between 1 and 7 years jail. Similarly, in 2015, the Korean Constitutional Court left it to the South Korean National Assembly to decide the appropriate length of time offenders should remain on the sex offenders registry after the court deemed a uniform 20 years too harsh for all cases. After deliberation, the National Assembly revised the law, and now the court can can keep the offender's personal information on the registry according to the gravity of the crime. Both South Korea and Hong Kong, interestingly, have deemed the blanket ban on prisoner voting incompatible with the right to vote. But interestingly, both courts did not dictate the details of an acceptable legislative sequel. Right? According to the court, so both courts, they said that, this is a matter of discretion. How long you draw the lines up to you. Just that the current line you drew was too disproportionate, was too harsh. Interestingly, the Hong Kong Legislative Council decided to allow all prisoners the right to vote, while the South Korean National Assembly responded by giving the vote to only prisoners sentenced to less than 1 year imprisonment. It's also very interesting to note that in Hong Kong and Taiwan, the top courts have coupled the use of the suspension order with a remedial reading provision that takes effect automatically if the legislature does nothing. Right? So the Hong Kong Court of Final Appeal in 2013 held that the Registrar of Marriages in Hong Kong in prohibiting a post-operative male-to-female transsexual from marrying in the capacity of her acquired gender have violated her right to marriage. While the Court of Final Appeal issued a delayed declaration of invalidity, it also gave the Hong Kong legislature 1 year to reform the law. But at the same time, the court held that it's necessary in principle that a remedial interpretation must be given to the law such that the transsexual would have the right to marry if no legislation occur at the end of the suspension period. True to form, Legislative Council refused to pass a law, and at the end of the grace period, the applicant had the right to marry automatically under the court-imposed remedial interpretation of the law that took effect at the end of the suspension order. And we see this remedial bite also issued by the Taiwanese Constitutional Court in 2017, when it declared that Taiwan's ban on same-sex marriage was unconstitutional. While it gave 3 years to the Legislative Council to fix the law, it also said if Taiwan did not do anything about it at the end of the 2 years, right, then all same-sex couples in Taiwan would be entitled to marry under the pre-existing matrimonial legislation. Interestingly, in Taiwan in 2019, before the grace period expires, the Legislative Yuan passed a separate legislation to confer matrimonial rights on same-sex couples that are comparable to opposite-sex ones. In a nutshell, what Ross's work, what my work, and many others have done is that we believe that governance is a field of partnership between the judiciary and the legislature. And we see all these innovative, interpretive, remedial strategies as a means by the courts to foster greater democratic deliberation and improve governmental performance. Because at the very end of the day, what it does is they actually conjoin the very best in judicial statecraft that Ross talked about, and the very best in adjudication. And I believe, and we believe, this is the virtue of dialogic or responsive judicial review. Thank you.
Great, thank you, Pojan. Let me now hand over to Dinesha.
Thank you, Rehan. Thank you to the Center for Comparative and Public Law for inviting me to respond to Ross's great work. Just for everyone's sort of background information, there's a bit of lightning and thundering going on in the background. So if I flinch, that's my reaction to it, but all is well so far. So I think I can speak for 15 minutes or so without any interruption. So in the minutes that are allotted to me, I'm hoping to do 4 things. One is to talk a little bit about how Ross's work and her case for responsive judicial review is a useful point of conversation and comparison for understanding difference. Because I'm speaking from the perspective of the experiences of judicial review in Sri Lanka. And through that understanding of difference, the possibility for contributing as a collective to that project of theorizing that she spoke to right at the end of her remarks. Second, I want to say a little bit about what I think is a responsive judicial review in Sri Lanka, given the specific conditions in Sri Lanka, and more specifically why I think the public trust doctrine as developed by Sri Lankan courts is a strong candidate for judicial review that looks like responsive judicial review. Thirdly, I want to zoom out and think about the role of the judiciary and what Jen spoke about, the idea of governance, the idea of dialogue and collaboration between the different branches of the state in the global south context, where again there are certain specific conditions and realities that we need to contend with. And finally, if time permits, I also want to say a few things about what I like about the model of comparative scholarship that I have seen Ross design and develop and promote in working on her own work. So to turn to the idea of difference for comparison and how I think it's useful for everyone concerned. As I say in my contribution to the special issue, Sri Lanka is one of the 38 out of 202 jurisdictions, according to the Constitute Project, which does not provide for judicial review of legislation. Sri Lanka's constitution specifically prohibits judicial review of legislation, allows for pre-enactment review of legislation. It specifically protects written and unwritten law, even if they contradict the fundamental rights chapter, and therefore falls into a very unique category of jurisdictions which do not really fit in an immediate way the kind of jurisdictions that Ross is looking at, or even if you go back further, what Eli was thinking about when he talked of responsive judicial review. Nevertheless, I think there is a lot of value in engaging with this idea of responsive judicial review for the following reasons. It is a reminder for the comparative law scholarly community that that there are jurisdictions that cannot participate in this conversation about dialogic review, judicial review of legislation, and have to deal with a different set of realities. And even though I think Eli's and Ross's engagement with judicial review is very sensitive to political process, political context, and history, there are still cases which find it difficult to engage in that conversation. And I'll speak to why that is the case in a minute. The second point why difference and comparison is useful is that because the difference gets highlighted, I think it opens up prospects for new conversations about the role of the judiciary. And here I'm thinking specifically of two ideas. One is the idea of state capture, which I'm thinking about more and more because of the experience that Sri Lanka is going through, and also the idea of crises. When jurisdictions go into crisis for whatever reason, then what is the role of the judiciary? So apart from the fact that comparison helps us to understand our own jurisdictions better, I think comparison also, in context of stark differences, help us to think of new conversations as well. So let me say a little bit about what I think is happening in Sri Lanka. So the first point is that if you think of Sri Lanka's democracy and political processes, Sri Lanka has been challenged from, I argue, from the time Sri Lankan state came to be, because of its colonial history and the fact that the very idea of the Sri Lankan state has been contested, particularly by minorities, ethnic minorities, which felt like the state did not represent them, and that issue continues to date. Secondly, under the 1978 Constitution, we have very specific experience of executive aggrandizement, this which has been written about extensively, and about how the executive presidency has in effect weakened checks and balances, but also the other two institutions, namely the legislature, but also the judiciary. Apart from that, more broadly, if you look at Sri Lanka's democracy, Sri Lanka's only had democratic changes of government so far. But if you look at segments like women and workers, you find that democracy has not really yielded the benefits of democratic governance for them. And currently, I think we are also in a situation where we are moving towards increased poverty and significant wealth inequalities. So why am I giving all this context? It's important, I think, to make the case that Sri Lanka is perhaps an example of a situation in which there is state capture. And what do I mean by state capture? What I mean very briefly is that the regular checks and balances have been ineffective, and state institutions are unable to work to protect the democratic minimum core, however you define it. And there is a push and pull that is involved here. So if that is the case, what is the role for judicial review, even in the limited context that the Sri Lankan Constitution provides for? So very briefly, there's pre-enactment judicial review. There's, like Pojen mentioned, fundamental rights related judicial review of executive administrative action, and the possibility of issuing writs, again, over executive and administrative action. And what we find since at least the 1990s is that the judiciary has embraced the idea of public trust doctrine, which is common to most common law lawyers, as a concept that is used in relation to environmental law and environmental justice. This has been used by the Sri Lankan judiciary periodically to do several things. One is to develop the point that public power and public office can only be used for the purpose for which the public office has been established and for which public power has been vested. Now, this is obvious. We all know this. This is the first principle you learn when you start learning law. But given the context that I'm speaking about, by using this, the judiciary has been able to, for instance, be innovative in offering remedies. It has been able to use it as a fundamental norm for which the judiciary stands. And almost every single time the judiciary has relied on the public trust doctrine, they invoke sovereignty of the people, which is also recognized in the Constitution. Now, going beyond that, they've also used the public trust doctrine to reaffirm, again, basic principles such as Parliament's control over public finance, and also to develop Sri Lanka's own version of environmental justice. Now, here again, something important to remember is that the public trust doctrine is not mentioned in the Sri Lankan Constitution, and all the jurisprudence on the public trust doctrine in Sri Lanka have been developed by the judiciary. Now, my own critique of the public trust doctrine is that the threshold is not clear, the scope has not been demarcated, and there is therefore no clarity on the limits for the public trust doctrine. And I used to be very critical of this, but thinking about this prompted by Ross's work and also the different conversations I have been part of, I'm also now beginning to wonder whether that is useful judicial strategy. I don't know whether it's intentional or unintentional, but given the context of jurisdictions like Sri Lanka, whether there is some degree of value to not clarifying some of these criteria which we as academics look for. Now, going a step further, why is it so important for judicial review to reinforce basic principles of public law? And I think to appreciate that in the Sri Lankan context, you need to account for the fact that you are dealing with a case of state capture. And here I want to digress a little bit to probe a little bit more the concept of representation that is involved in Ross's theory and what we've discussed so far. I could be wrong, but my own reading of the way in which responsive judicial review invokes representation is that there are assumptions, perhaps, of representing the people and the people as rights bearers. Now, if you flip that and look at some of these realities that we deal with, such as in Sri Lanka, where representation is majoritarian, representation is for sort of seeking privileges and access to power that you can only get by being the state. Right? If that's what representation, and if representation means dominance over minorities, whether ethnic or otherwise, if representation is experienced as patriarchy, then what kind of role does the judiciary have been seeing itself as being representative or responsive? So that's a difficult question for me, and I'm not sure of how to respond to that. But I think what I'm trying to get at is, if one takes the view that the 3 branches of the state or the 4 branches of the state are not working in the way they were meant to at a minimum level, is it then that the judiciary has a different role to play, even if they don't have the capacity for or the constitutional right to engage in judicial review of legislation? Now, there are risks involved, of course. There is overreach. There can be outright abuse and manipulation of this kind of judicial doctrine or judicial precedent, which can then result in pushback and direct threats to the judiciary as an independent institution. Now, I want to zoom out a little bit and think across jurisdictions. The jurisdictions that I'm familiar with mostly are in South Asia. Now, public trust doctrine has been used by the judiciary, created by the judiciary. And if we, and Rehan has, I think, also done a lot of work in this on this particular topic. Another similar experience is to do with public interest litigation. And if we take the Indian story of public interest litigation, we seem to have gone full circle. We've seen how the risks have played out, and there is, I think, it seems fair to say that there is a strong sort of concern about where this experience has taken different South Asian jurisdictions. But if we go back to the original sort of purpose or reason as to why public interest litigation emerged in the way it did in India and was and how it resonated with other South Asian jurisdictions, I think there are 3 fundamental problems. And I think these remain enduring problems for us. One is, as I said, the nature of the state and how the state came to be, how the state was formed, and the contestations around the identity of the state. And of course, I'm including the judiciary here. And finally, the function of law. So public interest litigation is also a response to the limits of legal judicial remedies and constitutional rights. And what if the kind of responsive judicial review you see in Sri Lanka is also some response to the limits of the law and the constitutional arrangements that you find. So the older book, Judicial in Plural Societies, published in the 80s, I think looks at some of the questions about judicial review from those broader perspectives. And I think these are useful book conversations to have. Ross's book, 2023, this older book, which asks these different questions about the role of the judiciary in places such as South Asia. So to come back to Eli and Ross Dixon and responsive judicial review, the interesting thing for me is that the questions or the concerns of Ross and still relevant even to these conversations in jurisdictions which look very different, because you're still concerned with how the judiciary should be responsive, what the judiciary should be responsive to, and the risks involved if the judiciary does not respond within a culture of restraint. Finally, before I finish, I just want to say a little bit about the model of comparative scholarship that I've seen Ross engage with in this work. I am now of the, I think, convinced view that comparative scholarship is best done collectively. So here is an example of Ross sort of carrying forward the work done previously, looking across different jurisdictions in conversation with scholars who've done that work on those jurisdictions, but she doesn't end there. Now, both of you share the published version of the book. This is the printed out version of a manuscript which she shared when she convened the special issue. So at early stage, I think Ross was responsive enough to know that there'll be others who will have different views about her manuscript and sort of actively invited us to engage in a very serious way. And I think that is a really excellent model for generating comparative scholarship. And then, of course, technology is also helping us today to join and connect and have those kinds of conversations. So I just want to acknowledge that and congratulate you really on sort of being committed to a truly inclusive, conversational model of comparative scholarship. I'll end there. Thank you.
Okay, thank you very much, Dinesha. Now turn to Roz in a minute for a response. But I also want to remind members of the audience, if you have questions, please put them in the Q&A because we'll come to that soon after. So Roz, please.
Thank you so much, Pojen and Dinesha, for those really generous and thoughtful remarks. Thank you for the opportunity to respond, Rehan, but I won't do justice to either of the remarks, but I'll try briefly before we open it up. So if I start with Pojen, and if you like, the furious agreement between us about certain aspects of dialogic review, I want to thank you, Pojen, for highlighting the importance of that statutory model as a means of engaging in responsive judicial review in diverse contexts, including in contexts where judicial review is in a more delicate balance in terms of the balance between commitments to the rule of law, democracy, and distinctive constitutional arrangements that are less democratic in orientation. I think it is a very important thing to highlight. And, we were recently in Tokyo talking about how similar themes could inform a Japanese understanding of responsive judicial review. I do want to suggest, however, two cautionary notes about the idea that the statutory turn is a complete panacea to accommodating the tensions that we've identified jointly and separately. The first is, I think, that there's a crucially important difference between liberty and dignity claims and equality claims, where on the one hand, reading down is a remedy available to courts to identify a rights-based violation versus reading in as a necessary solution. So where a law infringes on a common law right or freedom in a way that could be cured by reading down or creative statutory interpretation of the kind that Pojen notes, there's often a common law style principle of legality remedy available in a way that does minimal violence to the text and history of a statute, is weak form and dialogic in just the ways that Pojen notes, and has a great range of virtues. However, where the claim involves an equality claim, where the claim from the petitioner is that the statute is constitutionally under-inclusive, it is much harder for the judiciary to engage in this kind of statutory reinterpretation. As we are aware, one of the cases in the British context that attempted to do this, Guy Dan and Godin Mendoza, did stretch statutory language to what many people regard as its breaking point. Certainly in the High Court of Australia in Momcilovic, the court did not look favourably on that approach, seeing it as a departure from ordinary common law notions of statutory interpretation, even with a degree of creativity. The court said it was a breach of the separation of powers as they understood it. That is not to say I agree entirely with the High Court, but simply to note that traditional role conceptions of what statutory interpretation is or should entail are much more challenged where it involves legislation that is under-inclusive rather than over-inclusive. The second point is one I make in the book, and I do think is worth emphasising. Dialogue depends for its currency on statutory language. If I am a parliament that wishes to disagree with a court, the main tool I have available to me is the language of the statute. And if a court stretches constitutional and statutory language too far, but notably statutory language too far, it shuts off the most natural tool for legislative dialogue, which is why in my own work in responsive judicial review and earlier, I have raised questions and doubts about the desirability of a British-style Human Rights Act as a panacea for concerns about balancing overly weak and overly strong review, because I do think overly robust, creative statutory interpretation has dangers as well as advantages from a dialogic perspective, as well as from the perspective of those committed to a formal conception of the separation of powers. In the book, I call that backdoor strong review, and I raise some cautions about it. I want to suggest, therefore, that what POGEN offers is one very useful tool among many that a court committed to responsive judicial review could rely on. All of the examples you point to, Bojan, in relation to bail and reverse burdens of inertia, reverse burdens of proof, etc., I agree with and would embrace as instances of responsive review. But I think it is only one tool among many that must be available to have a fully responsive approach to judicial review. I also think your comments about remedial structures and innovation and the degree to which they depend on a certain degree of confidence in a legislative response are right and dovetail with what Dinesh has put on the table about the limits of this theory in extremely dysfunctional democratic polities. So turning to your remarks, Dinesh, thank you so much for your generosity and also for highlighting that collaborative dimension that you've helped me develop, but which I'm very committed to, and also for thinking through the importance of seeing similarity, but also difference as generative of new ways of thinking and theorizing, and highlighting, I think, two very important things in your own work and the work of others around state capture and this issue of how we think about state capacity and, notions of representation. Let me focus most particularly on what you said about representation. Supposing we think that in a particular polity that the notion of representation is not really democratic, but rather something like rent-seeking or domination over minority groups, representation as power, representation as self-serving interest, or influence seeking. I don't think in those cases the preconditions for responsive judicial review are met. And one of the things that I say at the outset of the book and in closing is that this is a theory of how to protect and promote democracy against the backdrop of a well-functioning minimum core. There can be degrees of, and there may be waxing and waning in that, but that it is the starting point for the theory. Yvonne too has asked me on numerous occasions, as have others, is this a theory that could be adapted to a context where democracy development, generation, creation is at stake? And I think it is a theory, but it could be adapted. It is not capable of straight out application. Because in those contexts, as you rightly say, pluralism, inclusion, non-domination may be just as important a set of values and constraints as democratic responsiveness, and they needed to be melded and balanced in ways that create a more complicated account of the relative priority of values. So my own view is that there is work to be done by people like you, others in the audience, possibly me at a later date, in thinking through how to create a more inclusive, good government promoting and non-domination oriented conception that would be melded with responsive judicial review in a way that is more overtly democracy building rather than protecting and promoting. But as you suggest, even within context in which there are deep flaws, there may be sufficient basis for this theory that it still has relevance even under current conditions. And there, as Pojen reminded me earlier about Hong Kong, one simply takes the parts of the theory that work and adapt it. And I think the work you've done in relation to the public trust doctrine is extremely innovative and shows the scope for a dialogue between local ideas and doctrines and context and theory in a way that's very generative. And I loved how you said it's a RJR-like account. It's not the same thing. It's just inspired by or has affinities with. And one of the things that I think that this kind of exercise does is it does force us to grapple with what our discipline really is about, which is seeing difference, similarity, difference all the way down in ways that are highly generative. I have done some recent work with colleagues in Central and Eastern Europe, thinking through how these ideas may or may not work in a Kelsenian court context where there are quite limited forms of ex post review. And in deeply interesting ways, there are more affinities with Sri Lanka there potentially than there are between Sri Lanka and, say, Hong Kong, Korea, Taiwan, or India. And the more I do this work in collaboration with scholars who know so much about countries about which I know so little, the more I am struck by the adage of that generativity to comparative constitutional law in the spirit of dialogue and collaboration that you know, which is same, different, same, different, same, different, and finding new ways of connecting jurisdictions across continents, contexts, histories to find similarity in ways that then force us to grapple with why are we still same and different in ways that promote better self-understanding, but critical self-understanding, with an understanding that always we're seeking not just to understand, but to improve, to deepen, to fully capture the potential of our own systems. And there are ways in which a public trust doctrine, as an example, is here's a doctrine that could be very formalistic, very narrow, or quite creative, quite robust and dynamic, that could embed within it many of the intimations of responsive judicial review that we've discussed, and which would be, in my view, a positive development for the rule of law and constitutionalism in a country such as Sri Lanka. I'm really looking forward to the further discussion. Thank you both for your incredibly rich and generous engagement and remarks.
Terrific. Thank you, Roz. So we have about 20 minutes or so left. So members of the audience, if you have questions,